Jefferson County Court at Law number 2 is now in session. We have two dockets, motion to revoke probation docket and the announcement docket, both scheduled at 9 a.m. on today's date of September 2nd of 2022. First case that we have is cause number 321-750. And the case is styled the state of Texas versus James T. Barnes or James Timothy Barnes. We have Mr. Barnes who's present in court. Mr. Barnes, is that your full name?
Yes, sir.
Mr. Barnes, you're present here with your attorney, James Paget. Mr. Paget, how are you doing?
Doing well.
Mr. Paget, did you waive a record in Mr. Barnes' case?
Yes, sure.
And Mr. Barnes, how are you doing?
I'm good.
That's good, the state is represented by Assistant District Attorney Raymond Shearer. Attorney Shearer, how are you doing?
Doing good, Your Honor.
And the probation office is represented by Mr. Gary Gilliam. Mr. Gilliam, how are you doing?
Very well, thanks.
Mr. Shearer, I have before me in cause number 321-750, a motion to dismiss the motion to revoke probation. And Mr. Shearer, you moving to dismiss this case?
Yes, Your Honor. As mentioned before, he's on probation. He's been placed on felony probation in Orange County. So this will basically, he's going to be continuing probation, but it'll just be for more serious charge in Orange County.
Okay.
He's been placed on 10 years deferred adjudication probation in Orange County.
Okay. Now, Mr. Barnes, I've just signed the motion to dismiss the motion to revoke your probation. And you will no longer be on probation. Well, hold on. His probation was all, December.
It's already expired. It's expired.
Yeah. Yeah. So you're no longer be on this probation here in this court. Okay, so I'm signing a motion. Your attorney is going to get a copy of the motion to dismiss. Once you get a copy of the motion to dismiss from your attorney, you'll be free to go, and you have a blessed day. All right. Court is in session in cause number 331-750. Case is style of state of Texas versus Unita Marie Lewis. Hey, how you doing? Miss Lewis, is your full name Unita Marie Lewis? Yes. Miss Lewis, would you please raise your right hand? Miss Lewis, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? You may put your hand down. How are you doing, Ms. Lewis?
I'm fine.
I'm doing fine. Thanks for asking. Ms. Lewis, you're here represented by your attorney, Attorney Marva Provo. Attorney Provo, how are you doing?
I'm doing fine, Mom.
That's good. Ms. Provo, do you waive a record in Ms. Lewis's case?
Yes, we do.
Ms. Lewis, I have before me a document that is titled Information. This information alleges that on or about May 2nd of 2020, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class B misdemeanor offense of driving while intoxicated. Ms. Lewis, do you understand what you have been charged with?
Yes, sir.
And to this charge, Ms. Lewis, how do you plead? Guilty, not guilty, or no contest?
No contest.
And do you plead no contest freely and voluntarily?
Yes, sir.
And do you plead no contest because you do not wish to fight or contest the charges?
Yes, sir.
Ms. Lewis, I also have before me a document that is titled Misdemeanor Plea Admonishment, which is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, Ms. Lewis, there's a set of initials, UL, that are on a line next to a box that's checked nola contingere, which means no contest. Did you place your initials on this document?
Yes, sir.
On the next page of the same document, there's a signature above the line that is titled Defendant. Is that your signature?
Yes, sir.
Next document that I have is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document? And is this your signature above the line that's titled Defendant?
Yes, sir.
There are two boxes that's checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes.
I also have before me a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line? It's titled Defendant. Ms. Lewis, before you sign and initial all of these documents that I've just mentioned to you, did your attorney, Ms. Provo, go over these documents with you?
Yes, sir.
And did you read and understand everything that she went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Ms. Lewis, are you a citizen of the United States? State, I have before me State's Exhibit 1, the misdemeanor plea admonishment, and also have before me State's Exhibit 2, the probable cause affidavit, which is in the court's file. State, you like to offer States 1 and 2?
State would, Your Honor.
Any objections?
No, Your Honor.
No objection. States Exhibits 1 and 2, and the court will take judicial notice of States Exhibits 2. Ms. Provo, you have advised and counseled Ms. Lewis, is there any evidence that she is currently mentally incompetent to stand trial?
No, no.
Ms. Lewis, your attorney, Ms. Provo, has advised and counseled you. Are you satisfied with her representation?
Yes, sir.
Has she provided full, effective, and competent legal representation?
Yes, sir.
Ms. Lewis, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there's sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor, we do.
What is that agreement?
The agreement is for Ms. Lewis to serve 180 days in Jefferson County Jail. However, that time will be probated over 12 months. She will receive a $500 fine and 60 hours of community service. And just to make the court aware, we're not asking for an interlock on this because there was no alcohol in her system. There was drugs on it.
Okay. Yeah. Now she'll be attending the standard DWI education class in alcohol assessment.
Yes, Your Honor.
Okay. Okay. Now, Ms. Lewis, the state is offering that you serve 180 days in Jefferson County Jail. However, you would not have to serve any time in the Jefferson County Jail because you will be placed on probation for 12 months. During the 12-month probationary period, you'll be required to pay a fine of $500 plus court costs of $422. The total fine and court costs is $922. You will also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You'll be required to reimburse Jefferson County Court-appointed attorney's fees of $250. You will be required to pay Jefferson County DWI education class an initial evaluation fee of $125. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is, the total amount that you will be required to pay each month while you are on probation, is $185 a month. Will you be able to pay the $185 each month?
I just had a job interview yesterday, so.
Do we have her? What'd you say?
I'm looking for a job.
Okay, I need her affidavit of indigence. Okay, let me. Ms. Provo, could you hand this to your client and have her to review that document?
Mhm.
Okay, now, Ms. Lewis, is that document still the same today?
Not the job.
Okay,
Everything else is.
You have a
not the
pen?
job.
did she scratch through and make the necessary changes? And she can just add it up.
Yeah. it's not working. You want her to initials?
She can. Did she
Yes, ma'am.
total it up?
It's not working.
Now, Ms. Lewis, I have before me an affidavit that you previously signed, but you made some corrections. Is everything on this document, the corrections that you made true and correct to the best of your knowledge?
Yes,
And the ones, the figures that was not changed, that's still the same?
Yes,
Okay. Ms. Lewis, the court is going to find that you are indigent and pursuant to Article 42.15 of the Texas Code of Criminal Procedure, the court is going to convert your $922 fine and court costs to 74 hours of community service.
Judge, is that on top of the 60 hours?
Yes. The fine, this is fine and court costs that's being converted to community service. And the probation fee of $60 is going to be reduced to the statutory minimum of $25 per month. Okay? So now, let me go over this again. The state is offering that you serve 180 days in the Jefferson County Jail. You will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 12 months. During the 12-month probationary period, you'll be required, the state is offering that you pay a $500 fine plus court costs, which comes to a total of $922. That $922 will be converted to 74 hours of community service pursuant to Article 42.15 Texas Code of Criminal Procedure. And the probation fees of $60 will be reduced to a statutory minimum of $25 because the court is finding that you are indigent. You also be required to pay this $15 each month, your analysis fee, reimburse the county to $250 for the appointed attorney's fees. You'll be required to pay the DWI education class and issue evaluation fee of $125 should a further evaluation be needed. You'll be required to pay an additional $50. Now, the probation department is going to make the adjustments on what needs to be paid, and they'll give you the total amount that you'll be paying, required to pay per month. It'll be substantially lower than what I initially said. Now, you also be required to perform 60 hours of community service in addition to the 74 hours of community service that was converted from the fine and court costs. You will be required to attend and complete a DWI education class and have a drug and alcohol assessment. And you also be required to perform the other standard conditions of this probation. Now, Ms. Lewis, do you understand the state's offer and the findings and adjustments that court has made in this case?
Yes, sir.
And do you think that is fair and just? And do you accept it? Okay, Ms. Lewis, I'll follow the plea bargain agreement with the findings that the court has made. In this court, the court is finding that you are indigent. The court is reducing your fine and court costs, or converting your fine and court costs to community service, and reducing your probation fee to the statutory minimum of $25 per month. Ms. Lewis, this will conclude your case. You're going to stand on the X next to your attorney, follow the directions of our clerk. Once you finish following her directions, you'll be free to go, and you have a blessed day. You're welcome. Yes. Jefferson County Court at Law number 2 is back in session and calls number 3322242. Case is style of State of Texas versus Franklin Oliver Ross. Mr. Ross, is that your full name?
Yes, it is, Your
Mr. Ross, how are you doing?
Good, Your Honor.
That's good. Mr. Ross, you're here with your attorney Nathan Reynolds. Attorney Reynolds, how are you doing?
Doing well, Judge.
That's good. And the state is present by Assistant District Attorney Lamar Johnson. Attorney Johnson, how are you doing?
I'm doing well, Your Honor. Thank you.
Mr. Reynolds, what is your announcement in Mr. Ross' case?
Judge, we've received discovery and an offer from the state, and we're asking that the case be placed on the trial docket.
Okay, give us the trial date.
January 9th.
Okay, this case will be reset, trial January 9th, 2023. That's our next available trial docket. Mr. Ross, your attorney is going to sign for your reset. Once you get your reset from your attorney, you'll be free to go, and you have a blessed day.
Thank you.
And you're welcome. And Mr. Reynolds, I think this is your only case.
Well, I had
You have another one?
had a gentleman who's got a warrant out for him, who was supposed to try to come in and take care of the case, but I don't see him.
Okay. Well, once you sign for his reset, you'll be free to go. You have a blessed day.
Thank you.
You're welcome. Oh, that's not it.
Go ahead.
court is in session and cause number 326234. Case is styled the state of Texas versus Brandon Joseph Roberson. Mr. Roberson, is that your full name?
Yes, sir.
I have some bond conditions in this case. Mr. Roberson, how are you doing?
I'm doing great.
That's good. Mr. Roberson, you're here represented by your attorney, Attorney Don Boudreaux. Attorney Boudreaux, how are you doing?
Just fine, sir, and you?
Oh, I'm doing fine. Thanks for asking. Mr. Boudreaux, what is your announcement in Mr. Roberson's case?
Your Honor, the state has offered a fairly decent offer, but there's a couple of things that we cannot agree upon, and we're probably thinking that with the court's permission, we might make an open plea to the court.
Okay.
Let the court decided. As I understand it, he was represented by Mr. Freeman some time back, and
Okay.
he moved out of the area. or
Well, I
something.
think he's a judge now, so he can't handle, he's a municipal court judge in Port Arthur, so
And I
thank you.
just got appointed fairly recently, but.
so you need some more time
No,
to,
sir, we're
okay.
prepared to go with the court's permission.
Well, you have to fill out the plea papers if it's gonna be open.
Okay,
Still have to fill out plea papers.
well, I'll do that, sir.
Okay. All right.
Good.
Yes.
May I ask another question? There was a gentleman,
Is it on this case?
no, sir, it's
Oh.
another case.
Oh, okay. Mr. Roberson, you can have a seat. Now, is that case on this docket?
It's already been disposed of, but Mr. Nix, put out, the guy's name is Nicholas Romero, and he pled guilty, and he was sentenced, in drug impact court, I think, to, 20 years, and I was.
So you need, so what you need to talk to the prosecutor about that?
Well, I was appointed on it, but the case got dismissed in checking it out, so I just wondered,
Well,
am I?
I mean, if, what are you saying?
I didn't have anything to do with the dismissal. It got
Well, I mean,
dismissed.
he had, well,
So I just wondered, is it?
Well, I mean, I can't tell you what to do on that. I mean, yeah.
I was hoping that it,
Oh, hold on a minute. This guy's trying to connect on Zoom. Yeah, but let's do this. Let's talk about that.
after.
We'll have to look at the file and stuff.
Okay.
Yeah, we don't have that case before us. Okay, thank you. Mr. Carver, put your mic on mute and you could take your video off at this time. And then when we call your case, you can bring it back up.
Yes, sir.
State's ready, go ahead and address Mr. Colbert.
Okay, he's at 10 o'clock. Hold on, Mr. Carver, just, the state said they're ready to address it. Let's see. He needs to, you know what? Okay. This is cause number 317312, case of style of state of Texas versus John Albert Culver. Mr. Culver is appearing via Zoom. Do I have his paperwork in that? His, that letter. Mr. Culver, your case was set for a hearing prior to your capious profile. And hold on a minute. Thank you. Okay, Now, Mr. Culver, I was looking at a letter that was sent to you back in July 8th of 2022.
Yes, sir.
It's titled Notice of Failure to Satisfy Judgment Prior to Issuance of Warrant. And I would imagine that that's why you're making your appearance in that case was set today. Is that correct?
Yes, sir.
Okay. Okay. So, Mr. Culver, we was looking, I think, in this letter. Well, first of all, Mr. Culver, the state is represented here by Attorney Raymond Shearer, Assistant Criminal District Attorney in this case. And Mr. Culver, I see that there is a balance of $104.26. Is that correct?
That's the letter I received. Yes, sir.
Okay, now, Mr. Culver, let me do this. Pursuant to Article 42.15 of the Texas Code of Criminal Procedure, well, actually, it's, Article 43.05 of the Texas Code of Criminal Procedure. The court is holding this hearing. Now, let me ask you this. The court must first hold a hearing to determine your ability to pay the remaining balance. Are you able to pay the $104.26?
I'm not able to pay anything right now. Back in December of 2020, I got into a wreck because I just received this letter.
Okay.
I am disabled right now and I'm trying to get disability.
Okay.
I had to have major back surgery where they put pins and rods in my back, and I'm going to have surgery again on my back.
Okay,
I am currently on probation as of right now.
I understand.
And she has taken into consideration that I am trying to get disability and SSI.
Okay, so right now, you basically informed the court that you have what we call an inability to pay because of your medical condition, as well as which also affects your ability to work and earn income. Is that correct?
Yes, sir. Yes, sir. And I do have letters from doctors saying that I cannot pick up more than 10 pounds. And I have tried every job, including fast food restaurants, corner stores. And because of my past employment that I've been making over $30 an hour, they don't want to train me because they think that I'm going to immediately take that job. I can't take those jobs anymore.
Okay, okay. Let me, you have a copy of this judgment? It was a fine only.
And honestly, I have a drug screen for a job that's supposed to be coming up.
Okay, state, you have anything?
The state is gonna examine this, and, you know, the state has made aware to the court that he is on probation. So we're gonna touch base with his probation officer. Mr. Gillen that's here was not aware of the probation since it's a felony, and try to confirm what Mr. Culver's telling us.
Okay.
And quite frankly, it is, as he says, then our recommendation to the court would be, we could write off the 104.
Okay, so Mr. Culver, what we're gonna do, the court will not be issuing a capious pro fine, which is a warrant.
Okay.
In this case. And so what we're going to do is we're going to reset a hearing. And what we're going to do, give you maybe about 60 days. Okay, give him we're going to give you, just hold on a minute. We're going to give you a reset date.
Okay. I'm gonna grab a pen real quick, so I'm gonna be off the camera for just 1 second.
Oh, that's fine, that's fine, that's fine. What day do we?
November 4th.
All right, I'm back.
Okay, this case, will be reset to November 4th.
November 4th.
Yes, November 4th of 2022.
Okay,
And we also gonna have it at 10 a.m.
at 10 a.m.
Right,
Okay,
same time. All right. So, Mr. Culver, this will conclude your hearing. You're free to go. You have a blessed day. And again, this hearing is set for November 4th of 2022 at 10 a.m. in County Court Law Number 2, Jefferson County.
sir, my probation officer has a letter from the doctor saying that I can't pick up more than 10 pounds, and it's a notice of to the disability.
Okay, the Jefferson County District Attorney's Office, they're going to look into all of that, okay?
Okay.
All right. So
Yes,
you
sir. You have a blessed day, sir.
We hope you have a full and speedy recovery.
You too.
All right.
Bye.
Bye.
Really?
He was trying to remove him. Yeah. Court is in session at cause number 328-800. Case is style of State of Texas versus Marco Antonio Flores. Mr. Flores, is that your full name?
Yes,
Mr. Flores, how are you doing?
I'm good. How are you?
I'm doing fine, thanks for asking. Mr. Flores, your case was reset on July 12th to give you an opportunity to hire an attorney. Have you hired your attorney?
No, I was gonna ask if I can reapply for,
See if you qualify for a
Yeah.
court-appointed attorney?
yeah, because right now I'm working the same hours, so I don't have the money right now.
Okay, Mr. Flores, just have a seat at that table right there, and right here,
Mhm.
you're right there, just have a seat, and our court bailiff is going to give you an affidavit of indigence to fill out. All right. We should Jefferson County Court at Law number 2 is back in session. The next case is cause number 329336, case is South of the State of Texas versus Tiana Nicole Lee. Ms. Lee, is your full name Tiana Nicole Lee? How are you doing? I'm doing fine. Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. Ms. Lee, you're represented by your attorney, Ryan Matuska. Attorney Matuska, how are you doing?
Where you are?
Good morning. And Mr. Matuska, you're waiving the record? Do you waive, do you want a record or do
Waive a
you waive a record? Okay, Mr. The state is represented by Attorney Lamar Johnson. Attorney Johnson, how are you doing?
I'm doing well, John.
That's good. Now, Ms. Lee, I have before me a document that is titled Information. This information alleges that on or about March 25th of 2021, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft. Ms. Lee, do you understand what you've been charged with?
Yes, sir.
And to this charge, Ms. Lee, how did you plead guilty? Not guilty, no contest.
Yes, sir.
Now, you're pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty? Yes? Okay. Now, Mr. Lee, I also have before me a document that is titled misdemeanor plea admonishment, is also labeled as State's Exhibit number 1. Do you recognize this document? On page 2 of the same document, there's a set of initials TL that are on a line next to a box that's checked guilty. Did you place your initials on this document? On the next page of the same document, there's a signature above the line that is titled defendant. Is that your signature? On the next document, it's titled trial court certification of defendant's right of appeal. Do you recognize this document? And is this your signature above the line that's titled defendant? You have the discovery certification.
Well, I left it in the table.
Okay, Ms. Lee, I have before me a document that is titled discovery certification. You recognize this document? And is this your signature on the line that's titled defendant? Now, Ms. Lee, before you sign and initial these documents that I've just mentioned to you, did your attorney go over these documents with you?
Yes, sir. We did.
And did you read and understand everything that he went over?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? State, I have before me State's Exhibit number 1, the misdemeanor plea admonishment. State, you like to offer State's 1?
Yes, Your Honor, State Officer.
Any objections?
No objection, Your Honor.
No objection. State's Exhibit number 1 will be admitted. Mr. Matuska, you've advised and counseled Ms. Lee. Is there any evidence that she is currently mentally incompetent to stand trial?
No, sir.
Ms. Lee, your attorney, Mr. Matuska, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir. We did.
Ms. Lee, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. Now, Ms. Lee, are you a citizen of the United States?
Yes, sir.
State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is that agreement?
In exchange for defendant's plea of guilty in this case, Your Honor, the state is recommending that the court defer finding of guilt, and that's that the court place defendant on community supervision for a period of 6 months. Require defendants to pay a $500 fine, to complete 60 hours of community service, and to pay $139 in restitution to Debris Bro.
$139
$39.
to Debbie Bro.
Yes, Your Honor.
Is that the evidence prevention program?
Yeah.
Okay.
Your Honor, my apologies. If instead of the loss prevention officer, Deborah Breed, that's who the officer was at Walmart. We just wanted to pay the restitution to Walmart.
Oh, Restitution is payable to Walmart. Ms. Lee, the state is offering that you serve, that you serve 6 months on deferred adjudicated probation. During the 6-month probationary period, you'll be required to pay a fine of $500 plus court costs of $412, which comes to a total of $912. You'll also be required to pay restitution in the amount of $139 to Walmart. You'll be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You will also be required to reimburse Jefferson County Court appointed attorney's fees of $250. Your total monthly installments for this is $335 per month. Will you be able to pay the $335 per month? You'll also be required to perform 60 hours of community service, and you will be required to adhere to the other standard terms and conditions of this probation. Ms. Lee, do you understand the state's offer?
Yes,
Do you think that the state's offer in your case is fair and just?
yes,
And do you accept the state's offer?
yes.
Ms. Lee, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Lee, if you successfully complete this probationary period, this will not result in a conviction on your record. This case will be dismissed, and you may qualify for a non-disclosure. Your attorney, Mr. Matuska, is quite competent on those matters, and you could talk to your attorney, Mr. Matuska, about the non-disclosure. Ms. Lee, you're gonna stand on the X next to Mr. Matuska. Gonna follow the directions of our clerk. Once you finish following her directions, you'll be free to go and you have a blessed day. Thank you.
Thank you.
You're welcome. Okay. This is cause number 3288800, case of style of state of Texas versus Marco Antonio Flores. Mr. Flores, is that your full name?
Yes.
Mr. Flores, would you please raise your right hand? Mr. Flores, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Mr. Flores, you may put your hand down. Now, Mr. Flores, I have before me a document that you have filled out that is titled Affidavit of Indigence. And do you recognize this document?
Yes.
You do? And on page, he's supposed to sign the, oh, he's not finished. It's not complete. You're supposed to read this information and then fill that information out. So just have a seat. You can have a seat. Next case is cause number 326234, case of style of the state of Texas versus Brandon Joseph Roberson. Mr. Roberson, is your full name Brandon Joseph Roberson?
Yes, sir.
Okay, this is cause number 326234. Mr. Roberson, would you please raise your right hand? Ms. Roberson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Roberson, you may put your hand down. How are you doing, Mr. Roberson?
I'm doing fine. You?
I'm doing fine. Thanks for asking, Mr. Roberson. You're here represented by your attorney, Attorney Don Boudreaux. Attorney Boudreaux, how are you doing?
Just fine, sir.
Mr. Boudreaux, do you waive a record in Mr. Roberson's case?
We'll waive that.
Okay. Mr. Roberson, I have before me a document that has been filed by the Jefferson County District Attorney's Office. This document is titled Information. This information alleges that on or about February 26th of 2020, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault, family violence. Mr. Roberson, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Roberson, how do you plead? Guilty, not guilty, no contest?
No contest.
Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Okay, now, Mr. Roberson, I also have before me a document that is titled Misdemeanor Plea Admonishment. Mr. Roberson, do you recognize this document?
Yes, sir.
On page 2 of this same document, Mr. Roberson, there are a set of initials BR that are on a line next to a box that's checked no contingency, which means no contest. Did you place your initials on this line?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
There are 2 boxes that's checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
We have the discovery certification. Did we fill that out?
No, sir.
Okay, I'll give you a minute to do that. Y'all can, okay, court is back in session in cause number 328800, case of style of state of Texas versus Marco Antonio Flores. Now, Mr. Flores, just raise your right hand again. Mr. Flores, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Flores, you may put your hand down. Mr. Flores, I have before me a document that is titled Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, Mr. Flores, there is a signature on the line that's titled Defendant. Is this your signature?
Yes, sir.
And Mr. Flores, prior to signing and initialing this document, did you read this document?
Yes, sir.
Did you understand what you read? Is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, now, Mr. Flores. Okay, now, Mr. Flores, based on your answers in this affidavit of indigence, you meet the eligibility requirements for the appointment of a court-appointed attorney. Well, actually, he's here. The attorney that's going to be appointed to represent you in this case is Attorney Don Boudreaux. Okay? Actually, Mr. Boudreaux is sitting right over there. If you. Yes, sir. Yeah, Mr. Boudreaux. Yeah, Mr. Boudreaux. That's your appointment. That's your the attorney that's appointed to represent you. Are you gonna give him he needs to come over?
Yeah, he needs to come.
If you stand over there by the court coordinator, she's gonna give you that information that you need. Once you get your information, you'll be free to talk to Mr. Boudreaux.
He's in.
Court is back in session in cause number 326-234, case of style, state of Texas versus Brandon Joseph Robeson. Brandon Joseph Robeson previously was sworn in. Brandon Joseph Robeson previously entered a plea of no contest to the charge, the Class A misdemeanor charge of assault family violence. Mr. Robeson acknowledged that his signatures and initials was on State's Exhibit 1, misdemeanor plea admonishment. He also acknowledged that his signature was on the trial court certification, and Mr. Robeson's attorney, Mr. Don Boudreaux, waived the record in Mr. Robeson's case. Now, Mr. Robeson, I also have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And Mr. Robeson, is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Robeson, before you signed and initialed all of these documents that I went over with you, or that I mentioned to you, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Robeson, are you a citizen of the United States?
Yes, sir.
State, I have before me State's Exhibit number 1 and State's Exhibit number 2, the misdemeanor plea admonishment. State, you like to offer State's Exhibit number 1 and 2?
Yes, Your Honor. Take 1 and 2.
Any objections?
No, sir.
No objection. State's Exhibits 1 and 2 are admitted. Mr. Boudreaux, you've advised and counseled Mr. Robeson. Is there any evidence that he is currently mentally incompetent to stand trial?
No, sir.
Mr. Robeson, your attorney, Mr. Boudreaux, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Robeson, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your pleas and waivers were freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
And in claims for defendants will be of no contest in this case. The state is recommending that the court defer finding of guilt and ask that the court place defendant on community supervision for a period of 12 months. Require defendants to pay a fine of $750 to complete 60 hours of community service. Have no contact with Kiara Watson, and to complete anger management classes.
Mr. Roberson, the state is offering that you serve 12 months of deferred adjudicated probation. During this 12-month deferred probationary period, you'll be required to pay a fine of $750 for the court costs. The total fine and court cost is $1,227. You'll also be required to pay a probation fee of $60 each month, a year analysis fee of $15 each month. You will be required to reimburse Jefferson County Court appointed attorney's fees of $250. Now, your total monthly installments, that is the total amount that you will be required to pay each month while you are on probation, is $210. Will you be able to pay the $210?
Yes, sir.
You'll also be required to perform 60 hours of community service. You will pay a fine of $100 to a family violence center in Jefferson County. You attend and complete anger management as a condition of this probation. You will have no contact with the victim, Kiara Watson, and you will adhere to the other standard terms and conditions of this probation. Mr. Roberson, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Roberson, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Roberson, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for non-disclosure. And you can talk to your attorney, Mr. Don Boudreaux, about a non-disclosure because he's quite competent on those matters. Now, Mr. Roberson, your attorney has handed you a document that is titled, could you hand it? Document that is titled Model Written Ammunition on Ineligibility to Possess Firearm Ammunition. Now, in accordance with the Texas Administrative Code, Section 176.1, the court hereby admonishes you or warns you of the following. Number one, you are by entry of order or judgment ineligible under Texas law to possess a firearm or ammunition. Number two, beginning now, if you possess a firearm or ammunition, it could lead to charges against you. If you have questions about how long you will be ineligible to possess a firearm or ammunition, you should consult an attorney. Number three, under Texas Penal Code Section 46.013A, firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. B, firearm does not include a firearm that may have as an integral part a folding knife blade or other characteristics of weapons made illegal by Penal Code Chapter 46, and that is one, an antique or curio firearm manufactured before 1899, or two, a replica of an antique or curio firearm manufactured before 1899, but only if the replica does not use rimfire or centerfire ammunition. The statutes listed below are a starting point for ineligibility to possess a firearm or ammunition. For more information about the laws that make you ineligible to possess a firearm or ammunition, or for more information on how long your ineligibility to possess a firearm or ammunition lasts, the court recommends you contact an attorney. Code of Criminal Procedure, Article 17.292, Magistrate's Orders for Emergency Protection. Code of Criminal Procedure, Article 42.0131, Notice for persons convicted of misdemeanors involving family violence. Penal Code Section 46.02, Unlawful carrying weapons. Penal Code Section 46.04, Unlawful possession of firearm. Penal Code Section 25.07, violation of certain court orders or conditions of bond in a family violence, child abuse or neglect, sexual assault or abuse, indecent assault, stalking, or trafficking case. Family Code Section 85.026, warning on protective order. Now, Mr. Robeson, the document that you have in your hand is your copy to keep. And this will conclude your case. You're gonna stand on the X next to your attorney, and follow the directions of our clerk. Once you finish following the directions of our clerk, you'll be free to go, and you have a blessed day.
Yes, sir, you too.
Thank you.
Thank you.
Yeah. And let's see, Mr. LeBlanc, you gotta stand by in case you need some. Okay. Okay, this is cause number 331706. The case is filed State of Texas versus Stanley Dion McDonald. We have Mr. Stanley Dion McDonald, who's present in court. Is that correct, Mr. McDonald?
Yes, sir.
And Mr. McDonald is pro se, however, he has a standby attorney, Attorney Todd LeBlanc. And Mr. LeBlanc is also present in court. And first of all, Mr. McDonald, how are you doing?
I can't complain, it makes stuff worse.
Okay. And Mr. LeBlanc, how are you doing? And the state is represented in this case by Attorney Raymond Shearer. Attorney Shearer, how are you doing?
Good, Your Honor.
Okay. Now, Mr. McDonald, I have a pro se motion that was filed. It's a motion for dismissal. Mr. McDonald, are you ready to proceed on this motion?
Yes, sir.
State, are you ready?
State's ready, Your Honor.
Okay, Mr. McDonald, you may proceed.
Well, correct me if I'm wrong, but today we gathered here for the prosecution rebuttal to my motion to dismiss, right?
Well, he's gonna respond to,
Okay, well, I just want to make sure that we know, lay that down. I filed a motion to dismiss on the basis of my constitutional amendment to a speedy trial. I've been going through this process for the past 2 years. I've been going to court for the past 3 months. I don't recall
now,
anymore.
Mr. McDonald, I'm looking at a motion for dismissal and it says request the honorable cases according to Code of Criminal Procedures, Title 1, Code of Criminal Procedures, Chapter 12, limitation, Article 12.02, misdemeanors.
Yes, sir, but that stems from what I believe was the Texas Sixth Amendment for the right to speedy trial, because you can't just stay in litigation forever. You have to come to some kind of a resolution.
Okay, okay.
That's the working interpretation that I'm with.
In reference to the speedy trial, the state's in agreement, and we're not opposed to that, so we can, as far as the speedy trial motion, whenever court wants to put it on the docket for a trial, we're fine with that.
Okay, that's fine. But let's, okay, so, but we have this other motion, and this other motion is saying, I guess, to a certain degree, it's a statute of limitation. It was filed beyond the statute of limitation. That's the way I read this motion.
Yes, sir.
Okay, so would you like to present this?
Yes, sir. Yes, that's what I'm trying to do, Your Honor. Maybe I went about it wrong, but let me rephrase. We're here to see if the state still has a right to prosecute me.
Okay,
After all these years, according to that statute, it says that the state has 2 years to prosecute a misdemeanor after the arrest date or whatever. Am I close to it after the arrest or after the incident, the time of the incident? So, and it's been past 2 years, Your Honor, and I would like to get on with my life. We're past the statute of limitations. Us as American citizens, we're bound by law, and if we don't live up to these laws, then we might as well not change the name to the United States or something else.
okay. Now, State, you like to respond to that?
Yes, Your Honor, I think that Mr. McDonald's concerns are the timely filing of the case, because the state has 2 years to present a misdemeanor. Mr. McDonald was arrested June 19th, 2020, and I think was booked in actually on the 20th, June 20th of 2020. This case was filed with the district clerk's office March 8th of 2022. And the state would present in support of that, the actual information, and the back is the file
You'd like
date
to show him?
stamp of when it was filed with the clerk's office. March 8th, 2022. So
You have any objections?
Yes, sir, I do, Your Honor, because the statute we're talking about doesn't say time.
But what I'm asking you is, He's presenting you.
I don't have any objection to his evidence. no.
Okay, no objections. Okay, State's Exhibit 1 will be admitted.
And Your Honor, in researching this, there was a blood warrant on this case. And it was submitted to the Jefferson County Crime Lab 2 days after the arrest, June 22nd of 2020. And the Jefferson County Crime Lab just determined there was no alcohol in his blood. So per their procedure, they forwarded it to the DPS lab. And the DPS lab received it July 15th of 2020. And the report from DPS did not come back till January 5th of 2022. So we have almost a year and a half there waiting for the lab results to come back from the Department of Public Safety. And then as presented to the court, this was actually presented and filed with the clerk's office in March 8th of 2022. So just a couple of months after the lab report came back, which still puts it under the 2-year statute of limitations, which would have been June 19th of 2022.
Okay, Mr. McDonald, you like to respond?
Yes, sir, I would, Your Honor. The statute that we were talking about doesn't say anything about waiting on the crime lab. It doesn't say anything about filing. It says prosecution. The state loses the right to prosecute if we are past the time that it is. The state has 2 years to prosecute, and it's 2 years is up, and the state is still prosecuting.
Okay,
So I mean,
and the statute you're speaking of is Article 12.02 of the Texas Code of Criminal Procedure. That's the article that you cited in your motion. Is that correct?
yes, sir.
Okay, now, Article 12.02 is titled, 12.02 of the Texas Code of Criminal Procedure is titled misdemeanors. And it reads, A, an indictment or information for any Class A or B or Class B misdemeanor may be presented within 2 years from the date of the commission of the offense and not afterwards. That's what it states. Now, this information that is part of State's Exhibits 1 state that this offense was committed on or about June 19th of 2020.
The offense was allegedly committed.
On or about,
Yes, sir.
right. And so the state had 2 years from June 19th of 2020 to present the information in this case. Presentment means to file. This case, according to this information, which is file stamped March 8th of 2022, falls within the 2-year statute of limitations date, because the statute of limitation date would have been June 19th, 2020 through June 18th of 2022. That would have been 2 years. So March 8th of 2022 falls within the 2 years statute of limitations. So this case was filed timely. Okay. So at this time, your motion to dismiss will be denied. You will be granted a motion to a speedy trial. And when is our next, when we have our next available trial docket? I know we have one in about, we can, let's see. We don't have a trial. We're gonna put your case on our next available trial docket, okay?
If I may, I think what is the term presentment,
Okay, go ahead.
the term presentment is probably where he may not be understanding that presentment. He believes that they should have already prosecuted and pursued this case and had it resolved within the 2-year
Right.
period. And with court permission, I mean, I don't know what my role is, but I'll explain that to him. And
Right, if he has any, yeah, that's what your role is, to
I'm starting to have,
assist him where he needs some assistance, if he asks you some questions.
and if you want me to help him through the trial, I don't have a problem with that.
Or you still is a standby attorney
Because I have some issues with it, that
throughout the process.
there was no alcohol.
Okay,
I mean,
well,
it's maybe
I mean,
something
but,
And
yeah,
that's
whatever assistance,
for the trial of fact and.
Right.
not-
okay, so at this time, let's do this.
September 26th, I mean, would that be a good day?
Well, I mean, that's fine.
Hold on, let's see, hold on a minute. Court is in session in cause number 323-990. The case is filed, the state of Texas versus Justice Chevalier. Mr. Chevalier. I don't have this, it's an MTRP. Well, this is Bond. This is Bond. Is Chevalier's motion up there? That's the only one I was thinking of. No? Okay, Mr. Chevalier, is that your full name, Justice Chevalier?
Justice Lee Chevalier.
Justice Lee Chevalier?
Yes.
How you doing, Mr. Chevalier?
I'm doing fine, Your Honor. How are you?
I'm doing fine, thanks for asking. Mr. Chevalier. Okay, Mr. Chevalier, I have before me a motion to revoke your unadjudicated probation that was filed by the Jefferson County District Attorney's Office on March 20th of 2020. In this motion, it alleges that you, Justice Chevalier, was tried in County Court at Law Number 2 of Jefferson County, Texas, on the 22nd day of October of 2019 for the offense of possession of marijuana. The court found that the evidence was sufficient beyond a reasonable doubt to support the finding of guilt for the offense of possession of marijuana, which is a Class B misdemeanor. However, the court deferred adjudication of guilt in this case and placed you on unadjudicated probation for a period of 1 year. In this motion, Mr. Chevalier, there are 10 allegations. If the court finds one of these allegations to be true, your unadjudicated probation may be revoked, and if it's revoked, you could be sentenced to 180 days in the Jefferson County Jail. Mr. Chevalier, do you understand that?
Yes.
Now, Mr. Chevalier, as a defendant in a criminal case, you have a right to have an attorney. You may hire an attorney, or number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number three, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including a loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. If you want to hire an attorney, this case will be reset. Now, I'll be giving you a document with the information that I've just read. At the bottom of that document, it states, mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, you put your initials on the first line to the left. If you have already hired an attorney to represent you in this case, then you'll put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you will put your initials on the third line to the left. If you have already been appointed a court-appointed attorney in this case, Then you will put your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right or waive your right to an attorney and represent yourself, then you will put your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign at the bottom of the document where it says defendant, and you will date it today's date, September 2nd of 2022. Now, you can have a seat at that table so that you can fully read the document and you can make your choice. Okay, just take that clipboard and the pen. Yes.
You said it was 10 allegations.
In the motion to revoke your unadjudicated probation.
What are they?
Well, first of all, okay, allegation number 1 states that the said Justice Chevalier committed the offense of display fictitious license plate on or about the 15th day of February 2020 in the county of Chambers, state of Texas, against the peace and dignity of the state in violation of condition number 1. Allegation number 2 states that Justice Chevalier committed the offense of possession of marijuana on or about the 18th of February 2020 in the county of Jefferson, state of Texas, against the peace and dignity of the state in violation of condition 1 of the defendant's probation order. Allegation number 3 alleges that the said Justice Chevalier failed to pay court assessed fees as ordered by the court, and as of February 28 of 2020, was $568 in arrears in violation of condition 8 of the defendant's probation order. Allegation number 4 states that the said Justice Chevalier failed to immediately report to the probation officer his arrest on February 15, 2020, as ordered by the court in violation of condition 11 of the defendant's probation order. Allegation number 5 alleges that the said Justice Chevalier failed to immediately report to the probation officer his arrest on February 18, 2020, as ordered by the court in violation of condition 11 of the defendant's probation order. Allegation number 6 alleges that the said Justice Chevalier failed to never become intoxicated or be under the influence of any intoxicating substance on or about February 18, 2020 in Jefferson County, Texas. The said Justice Chevalier did then and there become intoxicated and under the influence of an intoxicating substance in violation of condition 12 of the defendant's probation order. Allegation number 7 alleges that the said Justice Chevalier failed to perform community service required as ordered by the court in violation of condition 14 of the defendant's probation order. Allegation number 8 alleges that the said Justice Chevalier has failed to complete a drug education class as ordered by the court in violation of condition 15 of the defendant's probation order. Allegation number 9 alleges the said Justice Chevalier failed to report to the Jefferson County CSCD, which is a probation office, by mail for the months of December 2019, January, February 2020, in violation of special amended dated October 29th of 2019, of the defendant's probation order. Allegation number 10 alleges the said Justice Chevalier traveled out of Harris County for reason other than employment without permission in violation of special amendment dated October 29th of 2019 of the defendant's probation order. Now, those are the allegations. You can have a seat at that chair, fill out that form, and then we'll call you back up. Now, Mr. Chevalier, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document?
Yes. I recognize it.
And is this your signature on the line that's titled defendant?
Yes, that's my signature.
And are these your initials on the line stating that you want to reset this case and hire your own attorney?
Yes, Your Honor.
Now, Mr. Chevalier, before you sign and initial this document, did you read this document?
Yes.
And did you understand what you read?
Yes.
And is everything in this document true and correct to the best of your knowledge?
Yes.
Okay, Mr. Chevalier, your case will be reset to give you an opportunity to hire your attorney. And you're gonna stand on the X in front of our court coordinator. She will reset your case. Once your case is reset, Mr. Chevalier, you'll be free to go. And you have a blessed day.
Thank you.
Here you go.
You don't have court, you have
Jefferson County Court at Law number 2 is back in session. Next case is cause number 318300. Case is filed the state of Texas versus Ramon Joseph Robinson. Ramon Robinson was scheduled to be in court this morning at 9 a.m. for the court's announcement docket. At or about 9 a.m., Ramon Robinson's name was called at the courthouse door by the court's bailiff. Ramon Robinson did not answer. A reasonable time has passed to give Ramon Robinson an opportunity to appear in court. He has not appeared in court. And he has not appeared in court since the court has been in session. Mr. Bailiff, would you please call the name of Ramon Robinson at the courthouse door? The time now is 11:33 a.m. on today's date of September 2nd of 2022. Ramon Robinson? Ramon Robinson? No response, Your Honor. Okay. Ramon Robinson's name was just called at the courthouse door. Ramon Robinson did not answer. A reasonable time has passed to give Mr. Robinson an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
Yes, Your Honor, state motion going forward.
That motion will be granted. Ramon Robinson's bond will be forfeited and a warrant shall be issued for his arrest and cause number 318300. Jefferson County Court at Law is back in session and cause number 320404. The case is styled the state of Texas versus Amare Isaiah Howard. Amare Howard was scheduled to be in court for a hearing pursuant to Article 43.05 of the Texas Code of Criminal Procedure for the court to determine whether or not a capious pro fine should be issued for unpaid fines. Mr. Howard was scheduled to appear at 10 a.m. on today's date. At or about 10 a.m., Mr. Howard's name was called. Well, in the letter, it says at 9 a.m. He was supposed to appear at 9 a.m. At or about 9 a.m., Mr. Howard was scheduled to appear in County Court at Law number 2 to show cause whether or not a capious pro fine should not be issued. And the court was going to have a hearing to determine whether or not the defendant had the ability to pay the capers pro fine and to determine whether based on the evidence presented at the hearing. Mr. Howard is not present in court at this time. The time now is 11:37 a.m. on today's date. Mr. Bailiff, would you again call the name of Amari Howard at the courthouse door? Amari Howard. Amari Howard. No response, Your Honor. Okay, Amari Howard failed to appear. The courts find that the judgment in the above style cause number 320404. In that case, Amari Howard was to pay a fine and court costs of $752, which was rendered against him in this case, and the court finds that the defendant has failed to satisfy the judgment, and the balance is now $125.01. At this time, the court will order that a capers pro fine be issued for the balance of $125.01 for the defendant failing to appear at this hearing. And that is the order of the court. And this will conclude the calling of the court's motion to revoke probation docket and the announcement docket. Both dockets were scheduled on today's date of September 2nd of 2022. Everyone, please have a blessed day.